Morning, everyone. We're just going to give everybody a few more minutes to get settled in and get their sound turned up before we launch this webinar. All right. Well, good morning. My name is Courtney Baker. I work for the Associated General Contractors of Virginia. And today our webinar is on new Virginia construction statute. General contractors can be liable to pay for subcontractors' employees. We're joined today by 3 attorneys from Miles and Stockbridge. Miles and Stockbridge is a leading law firm with offices throughout the Mid-Atlantic region. The firm's more than 220 lawyers help global, national, local, and emerging business clients preserve and create value by helping them solve their most challenging problems. Its construction industry team represents general contractors, subcontractors, owners, suppliers, and sureties in all aspects of construction law, including contract drafting and negotiation, mechanics liens, bid protests, and litigation, arbitration, and mediation of construction claims. Before I introduce our presenters, just a few features of today's webinar. Everyone coming into the webinar will be muted. However, we do have a Q&A and little button at the bottom of your webinar so that you will be able to ask questions or make comments throughout the webinar, and we'll be sure to address them by the end of the session. So if you hover your mouse toward the bottom of your webinar screen, you'll see a little button that says Q&A, and that's where you can submit those questions or comments. Our 3 panelists today are Suzanne Decker, Thomas Wolf, and Jack Robb. Suzanne Decker is a principal and co-leader in the firm's labor and employment practice. She represents businesses in all aspects of employer-employee relations. Her experience includes defending employers in matters including wage and hour issues, discrimination and harassment, family medical leave, and ERISA denial of benefits. Tom Wolf heads the Richmond office of Miles and Stockbridge and co-leads the construction industry team. Tom is a longtime AGC member. He's represented contractors for more than 40 years, has taught construction law at the University of Richmond School of Law for more than 30 years, has authored many books and articles on construction law, and has been lead counsel in countless construction cases. Jack Robb is a construction attorney who has helped contractors and owners litigate and resolve claims for nearly 15 years. He's a former in-house general counsel and regularly advises clients on contracts and other business matters. He has authored numerous publications in the construction industry and has been recognized by Virginia Business Magazine as one of Virginia's legal elite and Law and Politics Magazine as a Virginia super lawyer. So with introductions being complete, I'm going to go ahead and turn it over to our panelists.
Good morning. We're here to talk about a surprising new Virginia statute that has potentially dramatic consequences for general contractors. The next slide, please. So go ahead to the next slide, please, Courtney. Here's what we're going to cover today. We're going to talk about the specific language of the statute, about the risks that are created for general contractors by this statute. We're going to talk about employment law issues that may not be apparent from reading the statute. We are going to give specific practical advice on what this statute means for you and what you need to do as a result of this statute to protect against the risks that it creates for your business. We're going to address some hypothetical questions to help you understand the impact and parameters of the statute, and then we will end with a Q&A session. Next slide, please. So, what's going on here? First question is, what prompted this really dramatic change in the law that potentially makes general contractors responsible for the wages of people they do not employ. I spoke with two senators who were instrumental in getting this passed, and they said that the impetus was the Laborers International Union and the Carpenters Union that were complaining about wage theft on projects that where, as they learned that members of their union were basically having their wages withheld and not being paid, and they seemed to have little recourse. So everybody knows that cash flow is a very significant issue for general contractors and subcontractors alike, and that there is always a temptation to use progress payments from one job to pay what's owed on another job, and that can put employees at a risk of not getting paid. And needless to say, recent developments in the economy with the pandemic have heightened this problem. Next slide, please.
Good morning. Thanks, Tom. This is Jack Robb. Let's talk about what the new law says. The AGC is going to circulate the PowerPoint presentation to all participants in the webinar. So we wanted to include the actual language of the statute. So if you're so inclined to dig into it, you'll have it. It's a little tricky the way the General Assembly has done this because they've enacted a new statute. That new statute incorporates definitions from a different statute, and they've changed the language of a third statute. We have already dug into that. So Sheila, if we could advance a few slides to number 9, let's talk about what the new law does. There we go. So the new law, 4 major effects. Number 1, it makes the general contractor liable for the wages of downstream subcontractors' employees. And the definition of subcontractor is pulled from the mechanics lien statutes for Virginia and includes suppliers. And like Tom said, so a general contractor can be liable for the wages of employees that it does not employ itself. Number 2, the new law requires that such wages equal or exceed those required by applicable statutes, including Virginia's Minimum Wage Act and the Fair Labor Standards Act. And Tom will tell you that this law was part of a package of about 10 laws that Governor Northup signed, all focused on employee rights as the Virginia General Assembly changed from Republican-led to Democrat-led for both houses and the governorship. Number 3, it deems contractors to be the employees of subcontractors and suppliers for purposes of Virginia Code 40.1-29, which is the employment section of the Virginia Code talking about penalties, both criminal and civil penalties for failing to pay employee wages when due. And then lastly, and this is the one that I think gives me at least the most consternation, employees now have several procedural advantages that they did not have before in this context, including allowing the filing of what's called a collective action. Suzanne's going to cover that. It's similar to a class action, but now employees can band together in state court and sue a general contractor for wage theft. Next slide, please. Sheila, could we please advance to the next slide? So the risk, the new law could lead to a wave of new employment lawsuits. This collective action, creates challenges. The new risks include these penalties, up to $1,000 per violation. If an employee prevails in the lawsuit, the employee is entitled to attorney's fees. And for knowing violations, the court could award triple damages. It's these attorney's fees and potentially enhanced damages that cause plaintiffs' attorneys to really go after these cases. We've had some conversations with some plaintiffs' attorneys that we have litigated against in the past, and they are really monitoring closely new opportunities. So because they're becoming more prepared, we need to become more prepared as well. So next slide. I think that's you. So we've talked about the risk. We've talked about the new law. We've talked about the risk. Let's talk about some limitations. That the law was subject to a committee process, and during the committee work, limitations were put into the law that are important to understand. So the law governs contracts only entered into after July 1st, 2020. It applies to large construction contracts valued at $500,000 or more, and it does not apply to single-family residential construction. The contract contains the statute contains express language allowing a contractor who has to pay employees under the new statute to recoup that from the subcontractor. That's typically provided for in indemnification language, but to the extent the indemnification language in your contract does not cover that, the statute implies that obligation. Tom's going to talk about ways in which you could use your indemnification language to create additional protections in this circumstance. And then there's a final limitation. Sheila, if we could go to the next slide. Tom, do you want to cover the knowing aspects of the statute and whether this could be protection or whether the General Assembly's created a lack of clarity here?
Sure, Jack. So the initial statute sailed through without the protection I'm about to talk about, but at some point in the committee, it was realized that this actually could be more draconian than we were trying to make it. And so this protection was put into the statute as a revision for the final passage. So the law applies only if the general contractor knew or should have known that the subcontractor was not paying his employees all wages due. Now, there's going to be significant litigation if this part of the statute is not clarified right away to determine, well, knew or should have known as of when. I think the most reasonable interpretation is knew or should have known as of the time when the employees should have been paid, the employees of the subcontractor. But it's not clear, and I can guarantee that some employees, lawyers for employees of subcontractors who did not get paid, are going to argue that, well, once the employee or group of employees notifies the general contractor that they haven't been paid, regardless of when that is, then the general contractor must pay them, or it's if he doesn't, it is a knowing refusal to meet his obligations under the statute and pay the subcontractor's employees as if they were the general contractor's employees. I don't think that will eventually be accepted by the courts, but it is definitely going to be argued. And the provision that allows for triple damages, this is a really severe penalty on top of having to pay the wages of the subcontractor's employees. This would apply if the general contractor has actual knowledge that the sub's employees were not being paid and acts in deliberate ignorance of the truth or falsity of the information. That is, has the actual knowledge or acts in deliberate ignorance of the truth or falsity of information that may have been received by rumor, or acts in reckless disregard of the truth or falsity of the information. That is, the general contractor receives information that would put him on notice and says, well, I don't care. I'm not going to do anything about it. I'm not going to see that they got paid. I'm not going to withhold money from the subcontractor to make sure they get paid. That kind of thing. Next slide, please. So it's also not clear who has the burden to demonstrate the general contractor's knowledge. Normally, one would think that burden would be on the employees who are insisting that the general contractor has to pay them. But it's really not clear under the statute whether the employee has to prove that or the general contractor has to prove that he didn't know. And then if the general contractor pays a sub without knowledge that the subcontractor had not previously paid employees on the job, is that a defense that the general contractor can use? In the mechanics lien statute, there is a specific provision that says if the general contractor has paid the subcontractor everything that the subcontractor is due, then the subcontractor cannot enforce a lien. That express defense is missing in this statute. And so probably the payment to the subcontractor of everything that was due to the subcontractor is not going to be a recognized defense for the general contractor. Next slide, please.
All right, thanks, Tom. I'm going to talk for a minute about some of the employment law considerations. And I'm going to start first with what Jack mentioned earlier, which are the wage and hour and the collective actions. Understand that in Virginia, prior to January of this year, I couldn't sue my employer for wages that I didn't receive. I had to go to the Department of Labor in Virginia and get them to take the action on my behalf. So in Virginia, we've never seen the amount of wage and hour litigation that we've seen in other states. And so I think broadly, it's going to be a sea change. And then when you talk about the collective actions that are going to be allowed, and you think collective action, class action, boy, that sounds like a lot of lawyer doublespeak. And I'll tell you that it sort of is. What these are these are claims that are very easy for plaintiffs to bring. And we see them under the Fair Labor Standards Act, which has, as Jack was talking about earlier, a lot of this statute encompasses a lot of those thoughts related to collective action or a way to get wages as a group. And just to understand what the practice is for that, all you have to have is one or two employees who say that the company followed a policy of not paying them. Then the court allows them to give notice. You have to help them send out a letter to every employee who might have been not paid on that work site. And they have the ability to sign a form and opt in. And I will say that when a letter comes to employees that says you might be entitled to a little free money, people jump on board and become class members. And the thing that becomes most troublesome of these cases are the attorney's fees. So a person could be due $1,000. And in a lot of these types of actions, that's what they're entitled to in terms of lost wages is $1,000. And the attorney's fees that you're responsible for are $160,000. I mean, they bear no relation to the wages that are owed to these people. So what's happened is this is a great option for the plaintiff's bar. And so what you have seen related to the Fair Labor Standards Act wage cases is that there are more of these pending nationwide than discrimination cases because they're far more lucrative for the plaintiff's bar, because they're going to get paid no matter what, because almost no one is able to pay perfectly. And a little secret that I probably wouldn't want others to know, but I'm sure there's someone in our own law firm that we didn't pay correctly, because it's so hard to comply with all of these rules on how you pay people. And so it's very hard to get out of these pieces of litigation once they take off. So some other considerations, you want to avoid that certainly at all costs. And Tom's going to talk in a minute about some ways that you can work with your subs on that. But my other concern with the way the law is written is that this joint employer concept extends to other areas that create liability for you. Because as the general, now hey, I might be liable for the wages of my subs. I better make sure they're paying their subs correctly. And as soon as we begin to jump in and really micromanage your subcontractors related to their employees, you begin to look a lot more like the employer of those employees. And therefore, lots of other laws in the employment realm begin to extend to you. So I feel like this is sort of a damned if you do and damned if you don't statute, because you've really got to thread the needle and make sure, am I taking the steps to make sure that I'm not going to have liability from one of my subs who didn't pay their employees appropriately? But how do I make sure that I don't look like the employer and therefore might be, held accountable for a whole bunch of other laws, such as discrimination laws, for this group of people who I have no control over? You're not even going to know the names of these people. How can you be responsible for them? So I think it's important. So for some of my clients who have unsophisticated subs, because this law has been in effect, or similar parts to this law have been in effect in the DC market and in Maryland for a couple of years. And so for those of my clients who want to make sure that their subcontractors are paying appropriately, especially where they have unsophisticated subs, is they've begun to do some educating and taking on the task of making sure that their subs understand what the law is related to those payments, that they understand how to pay them. I mean, you'd be surprised at certain levels how unsophisticated a sub can be. Many believe that you only have to pay once they've been paid by the general contractor, or that they only have to pay on a piecemeal basis after it's over. Or as I've indicated on here, they believe they're independent contractors and can be paid on a different basis. So that lack of sophistication is what puts you at risk under this statute that people might not be paid. So one option is to begin some training of your subs. The other thought is, how are you interacting with your subs employees? And Tom was just talking about whether you had knowledge or notice or knew or should have known. And I think on a work site, what happens is the employees point to the general contractor supervisor who's on that work site as the supervisor. Hey, that guy kept track of my hours. That guy I told I didn't think I was getting paid correctly. So as general contractors, you also want to make sure that your supervisors, if they hear any inkling that the subs employees aren't being paid, they need to bring that to management's attention immediately, because that way you can avoid these types of claims. So it's important, thinking about making sure that those employees know, who's really tracking the hours, who's making sure they got paid, who are they complaining to. That's going to be important. I touched on the independent contractor issue. Often where you've got a sub with 1 or 2 employees, they think they're independent contractors. Not really the case. They may actually be employees, and you can be liable for that. The other that I have a lot of concern about, which just happened also in Virginia, and which is, I think, part of that grouping of laws that Tom and Jack were talking about, very focused on employee rights, was the Virginia Human Rights Act that's been amended by the VVA, which gives a lot of rights and the ability to bring discrimination litigation in state courts in Virginia. And here's my concern and my tie-in. If this joint employer concept extends and you start looking more like the employer than the general contractor, there's a whole lot of other laws with claims that could be brought against you. And so it's really making sure that you make very clear you're not the employer for any other purpose than just the law here. So now I turn it back to Tom to talk about some of the ways in which you can work to protect yourself.
Okay, next slide, please. So, do you need to do anything as a result of this statute? The answer to that is absolutely yes. If you are a general contractor and you don't take specific steps to protect yourself, you can find yourself in deep trouble because of this statute. So what can you do? First, it makes it all the more important to hire subcontractors who are solvent and are going to be able to pay their employees, as well as have a reputation for actually paying their employees what they are owed. And one of the most troublesome things is the FLSA, the Fair Labor Standards Act, governs overtime payment requirements. So you may have, as a general contractor, no idea whether your subcontractors are adhering to the overtime payment requirements. As Suzanne mentioned, it is almost impossible for somebody to get that 100% right. And so you could find even at the end of the job that all the subcontractors' employees have been paid their hourly wages, but they were not paid overtime that you didn't even realize they were due. And so if it comes to your attention that they haven't been paid the overtime, when is that knowledge attributed to you? When do you become liable for the unpaid overtime? That is an unanswered question under the statute, but it is a danger. So, better pre-qualification of your subcontractors and getting sworn financial information from them to have them demonstrate that they have the wherewithal to actually pay their employees. Next is to get specific indemnification agreement from the subcontractors. Now, the statute already provides for indemnification by the subcontractor to the general contractor, but you want to make it clear that you're entitled to be indemnified for everything, which it would include all of the expense that you're going to have to incur just to pay those unpaid wages. It's not just a matter of writing the checks to the employees, but there's a lot of your own personnel time that will be involved, as well as attorney's fees and other costs. And so you want to make sure that your indemnification agreement with the subcontractors is as broad as possible, and wherever possible to get the personal guarantees of the owners of that subcontractor. I know that's always a delicate issue, but if you have any question about whether the subcontractor is going to be able to and will follow through in paying its employees everything due to them, then you want to try to get those personal guarantees. Third, you want to get a sworn certification of timely payment of employees every time the subcontractor gives you a payment application. And that sworn certification needs to state that they actually have paid their employees everything that is due before then, and they will that they have the ability to and will follow through in paying their employees everything due on future pay applications. Even though it's going to make projects more expensive, you will probably want to, if you have any question about whether the subcontractor can and will pay its employees appropriately, then you want to get a wage payment bond. And you can talk to your surety about what that will cost. Obviously, it will increase the cost of performance of the project, but it may be a necessary protection for you. Next slide, please. Your employment practices liability insurance is going to become more important, both in terms of its limits, how much it covers in terms of dollars, but also you will have to look carefully at the exclusions of your policy. It is not at all clear that the usual employment practices liability insurance policy would cover your loss in the event that you end up having to pay subcontractors' employees their wages. And so you may need to get a specific rider to cover that on your insurance policy. And as a last resort, you can issue joint checks to the subcontractors and their employees. That would be an administrative burden beyond what most people would ever expect, but that would be a way of ensuring that the subcontractor who you have decided you can't trust to pay the employee must actually pay those employees. Next slide, please.
All right. Well, I see we have some good questions coming in and we've got time. So I think we're going to address those questions at the end. We do have 3 hypotheticals to run through. So Tom, let me read the first hypothetical and pose it to you to see how some of the things we've talked about works in practice. So in this hypo, I'm the project manager. I'm at a monthly meeting and my site superintendent tells me that we're behind schedule on framing. I asked what's going on and the superintendent says he's heard that the framer's not paying some of his guys. What do I need to do as the project manager to help avoid potential liability under the new statute?
Well, I would say that in that scenario, the general contractor has been put on notice that the subcontractor's employees may not be getting paid. And therefore, if from that point forward, if those employees don't get paid, the general contractor could be liable, I think would be liable to pay those employees. So then the question is, well, what do you do about it? And you would need to talk specifically with the subcontractor and find out what the true status is, and then get proof that the money that you pay them is going to pay their employees. And that could be something that is, copies of the paychecks that are going out. You can put the money into escrow if you have to be drawn from an escrow account to pay those employees. But if you merely continue without doing anything to ensure that the subcontractor's employees get paid after you are on notice, you are going to be liable for the unpaid wages under this new statute.
Next slide. Let's take a look at the second hypothetical, please. All right, Tom, I'm going to ask you this one too. So in this one, I I received a call from an HVAC supplier hired by one of our mechanical subcontractors, right? So this is downstream from one of our subs. The supplier says that they have not been paid. They've got payroll to make and asked when we're going to pay the mechanical sub that hired the HVAC supplier. I say, I'll call you back. I go check the payment records on the file and I see we've already paid the sub last month, including for that supplier's invoice. How does this new statute create potential liability for me for one of my subcontractors' suppliers?
Right. So the statute incorporates the mechanics lien statute definition of a subcontractor. And under the mechanics lien statute, a subcontractor is somebody who has a contract with the general contractor, not with the owner. So a supplier to my subcontractor is not a subcontractor. I believe that it's clear under the statute that the general contractor will not be responsible for the wages of a subcontractor or a supplier to a subcontractor. However, in this scenario, the question is, does this put the general contractor on notice that maybe the mechanical subcontractor has not paid its employees? If it has not paid its supplier, is that a red flag that, well, maybe they haven't paid their employees either? Certainly a plaintiff's employment lawyer would make that argument. But in this scenario, the general contractor is going to have to immediately contact the subcontractor and demand proof that it has paid its employees. Hopefully, if it learns that the employees have not been paid in a timely fashion, there will be money that can be withheld from the next payment so that that money can go to pay the employees of the subcontractor.
And so what happens if I call the subcontractor and say, hey, you know, your supplier said that they haven't gotten paid and I've got concerns about your financial stability, and the subcontractor who has been paid acknowledges they have not paid their employees? What do I do now?
I think this raises the question that is unclear in the statute of at what point do you assess the general contractor's knowledge? What would make sense is at the time that the general contractor pays its subcontractor, does the general contractor have reason to believe the subcontractor is not paying its employees? That's what would make the most sense, right? Because the general contractor should not have to pay twice. But the statute, unfortunately, is not clear about that. If right after the subcontractor is paid by the general contractor then learns, oh, this guy's not paying his employees, is that when the knowledge requirement is assessed? And if those employees then turn at that point to the general contractor and say, hey, we haven't been getting paid, does the general contractor have a duty to pay them? The rational answer would be no. He's already paid the subcontractor at a time when the general contractor had no reason to believe that the subcontractor was not paying his employees, and that should be the test. But again, the statute is not clear, and the only way it will become clear is to be modified by the General Assembly or for courts to interpret it. And that will, if it's either one of those is going to take time. It's not going to happen probably this year. So unfortunately, what this means is that general contractor just has to be hyper vigilant about making sure that his subcontractors' employees are getting paid. Now, for a lot of subcontractors, is that really a serious risk? No. I mean, if these are subcontractors who are, doing very well and you work with them a lot, you know them, trust them, probably not going to be an issue. But for a significant, in my experience representing general contractors for more than 40 years, there are always those subs where you have questions, and you will have to be hyper vigilant about making sure they're paying their employees.
And of course, I may have other things I need to do because this could be a breach, right? So I may have written notice requirements to the subcontractor. If there's a payment bond in place, I may have to let the surety know. We've done some publishing on this, and the National Association of Surety Bond Producers is all over this statute, and I anticipate they will be offering opportunities to assist contractors and subcontractors with payment bonds, which candidly, as a Virginia lawyer, I had no familiarity with until the statute was passed. All right, Sheila, last hypothetical, please. Next slide. All right, Suzanne, I'm going to ask you this hypothetical. So, ma'am, we had a great job. Work got completed. Owner is happy. It was one of my largest projects. And I opened the mail a week later, and I see a letter from a plaintiff's attorney that I saw on a billboard going down I-95. And the plaintiff's attorney asserts that she represents some of my employees and represents employees of my subcontractor, and that my subcontractor's employees have not been paid. It demands payments within 10 days, or they're going to sue and seek attorney's fees and treble damages. What do I do? Do I call the lawyer up and say, what are you doing?
That's a great point. The one thing you don't want to do is simply forward the letter to your sub and say, take care of it, and never think about it again. Because now you've got some liability, right? Like you're on notice, you have some information, and you want to get this dealt with as soon as practical, but not be extorted. And so if we look at this, the most important thing you want to do is start gathering information, because here's the crazy part. You're the prime, you're the general contractor. You have no idea who these employees are, what hours they worked, or what they were paid. So I think it's really, are you going to reach down to your sub and try to get the information? Now, the interesting part, and I think Tom's really right on this, which is typically your first tier subcontractors, this isn't where you're going to see the issue, because you've had long-standing relationships with them. You've delved into their financials to make sure they're legitimate. This might be a second or third tier down sub on a project, and you're still going to be responsible for them. So in my practice, I've done a lot of representing of that first tier subcontractor. And what I have found, a little secret here, is they are terrified of these types of claims because it's their subs who created this problem for the general contractor. And so often that first line sub will take a lot of ownership of this because they don't want the general contractor to think poorly of them. And so you can get a lot of cooperation at that first tier sub level. And, for some of them, they're willing to pay it quickly to get it out of the way, and then they'll go after their second or third tier sub. Now, there's a lot of logistics involved in that, but that is a pressure point in these types of claims, and one to think about. And on the flip side, for that sub, it's important for them to have a really good idea of the people that they're doing business with and whether appropriate records are going to be kept. So what you're going to want to do after you call your own lawyer, is probably try to buy a little bit more time, because 10 days, while it may sound like a long time, is a really short period of time to try to get the records. But what you're going to do is try to get a handle on how large is this issue and what are the pros and cons of trying to settle it early. And as I talked about before, the attorney's fees that are guaranteed under these claims really make these difficult to settle if you don't settle it early, because the lawyer begins to get invested in all of the fees. And so you're really looking at, okay, can I get enough information to know who's actually worked, what they weren't paid for, and get the subcontractor to get you that information. And as Jack was saying, there may be obligations under your contract related to the notice that you have to give here, and that may be pretty prompt. And or if you were able to get EPLI insurance, notifying your insurer of the claim at least pretty quickly. So I think that's sort of the initial step once you see that letter, after you take a few Tums and figure it out. But you want to try to get as much information as quickly as possible so that you can have a response to this lawyer. And sometimes it's, no, these people did get paid, but I've had circumstances where, the sub was paying people in cash. And so then there wasn't a real record of the wages paid. And so making sure, okay, is there a way to create a record of this? Do we need to look at can we see where money was taken out of the bank? Can we put it together in a bunch of different ways? And sometimes that's having to be creative because you don't have the records, and trying to decide, is it worth paying now? Or is it something where you want to fight on it? And if you're going to fight, are there other people who have kind of a stake in this who are willing to support you on this? Because let's say, for example, you wanted to just pay these people off. How would you even know? You don't have any W-2 for them. You don't have a 1099. How would you issue paychecks to them? How would you know, what taxes to take out? You're not the employer, so how would you even submit that money to the IRS or the state comptroller? So there's a whole bunch of issues. It's not as easy as just stroking a check to make it go away. So that's sort of my initial thought on how you'd look at it.
Yeah, I'm probably going to ask my lawyer for help avoiding disruption. I mean, if the project's still going on, or if this is a great subcontractor, I have these claims sort of catch wildfire in the job site, and the plaintiff's attorneys are, hanging outside the gates and going to, for coffee. And then I'm also probably going to talk with my lawyer about how not to make it worse, right? I mean, I call up the sub and I say, man, you got to fire all those guys. I mean, now we're into retaliation and other claims like that. So,
Absolutely. And those are more costly than even the wage claim.
So, Courtney, I see we've got a lot of good questions. Do you want to take a look at the questions and pose them, and Tom or Suzanne and I can, answer?
Absolutely. Yeah. Lots of good questions. We'll try to get through them in the last, 10 minutes of our webinar. So first question is, if a subcontract is signed before July 1st, but a sub-tier contract is not signed until after July 1st, is the GC still liable for those sub-tier employee wages?
So this is Tom. I'll take that one. The answer is no. And the reason is that the statute applies only to contracts entered into after July 1. So you've got no control over what your subcontractors, what contracts they enter into with whom or when. So, but the governing issue is going to be, when did you enter into your contract?
Suzanne, when you were discussing joint employer concepts, extending liability, somebody asked, does this only apply to employees working on site? For example, wondering about those who may be working off site doing prefabricated portions of work.
So I do not believe that it's limited to the specific work site. And that's seen sort of in how broadly they look at suppliers and all of the rest. That it is going to, they're going to want it tied to the project. But even that, I mean, is going to be kind of hard to do. So I think it's a lot. The plaintiff's bar is going to read it a lot broader than certainly employees on site, and there's nothing in the statute that's going to limit that so far. There could be regulations that come out that help define that.
Perfect. Someone asked, they're a professional service firm providing land surveying services. Therefore, they do not provide bonds. Do you anticipate that wage payment bonds would pertain to professional firms moving forward?
This is Jack. I'd be happy to address that. So I think it's very unusual for bonds to be associated with professional services firms. You know, a bond is part of a collateral security discussion, right? And if you are able to demonstrate that your firm is financially secure, if you can provide indemnification that is meaningful, you know, if there's a problem with your employees and the general contractor pays out and comes to you and says, hey, you've got to make this right, and you can make that obligation. Those are the kinds of things I would focus on and resist having to provide a bond. If you have to provide a bond, there's a cost associated with that. And depending on your relationship with the general contractor, you would look to pass that cost along. So I think that, you know, most professional services firms won't be expected to provide bonds, but that really just depends on the economic climate, the size of the job, and the owner and general contractor's comfort with the people doing the work for the job.
Perfect. Next question. If my contract agreement states that subcontractor must agree to work overtime as necessary to keep up with my schedule, have I just assumed liability for their overtime wages in the event of a wage dispute?
Suzanne, you want to take that, or I'll take it, either one?
I'll take it. So I think it goes back. I don't think that statement alone is notice or knew or should have known that the employees weren't getting paid. You'd want to have with this, you know, your contract's going to want to have a provision that says, you know, you are paying your employees, or that certification that Tom's asking for that says you've already paid your, you know, overtime and regular payments. I don't think just the contract is going to give you that assumption of liability without a little something more to know that they weren't being paid.
Next question is from a banking standpoint. If the GC is a borrower or co-borrower on the bank loan, can the lien attach to the loan regarding future advances?
So I'll take this. The mechanics lien doesn't attach to a loan. It attaches to the land and the improvements to the land. And there is no lien that is created by this statute. So the mechanics lien statute governs the priority of liens. And as difficult as it is to comply with the mechanics lien statute in Virginia, the one advantage that it has for mechanics lienors over most other states is that it gives a super priority to the mechanics lien and puts it ahead of everything other than a purchase money deed of trust, that is the loan that was put on the property to buy the property. So the mechanics lien, and I think whether the GC is a borrower or a co-borrower really doesn't affect the lien rights. It will affect the relationship between the general contractor and the bank. So the bank may be able to grab money that would otherwise be due to the general contractor because of its loan documents, but it won't affect the lien priorities.
If the employees sue and obtain a judgment, that judgment against the contractor could be a technical default under the loan documents.
So if a GC or a sub have a sub that does not pay their employees and the GC or sub pays these employees, are they also responsible for payment of payroll taxes? If the answer is yes, it seems that could be extremely difficult.
It is, let me make sure I'm off mute. It is extremely difficult. So some contractors get around it by simply giving them out as 1099. So the wages have been reported to the government and the employee decides which portion of the payroll deductions that they're going to make. The problem is more the FICA that didn't get paid, the the medical, Medicare portion of it, the Social Security portion of it that didn't get paid. It can make it difficult. There are some ways to work with the subs to get the payments made through their payroll, even if you're just giving that sub the money to make the payments. But you're right, it increases the level of difficulty in trying to resolve it quickly.
Next question is, we work nationally, but our contracts are governed by the laws of the state of Virginia. Does this potentially give employees of some contractors in other states rights in accordance with this statute?
So that is a great,
Tom.
and I think the answer is no, but the statute is really not clear. It doesn't say that it applies only to projects in Virginia, but it would be hard to impose the requirements of a Virginia statute on a subcontractor working in another state. So I think this is going to have to be probably litigated, but the way to avoid it would be in your contracts out of state. You can simply make it clear, I think, that this statute does not apply because the project is not in Virginia.
I would agree with Tom.
I want to say that you can't exempt yourself from compliance with the statute in Virginia, but there is nothing that when you impose Virginia law on a subcontractor for a project out of state, there's nothing that requires you to impose every single statute of Virginia law. So if it's out of state, you can exclude the application of this statute.
I think this next question kind of dovetails into what we were talking about earlier with on-site employees. So will subs need to provide that they paid all employees, field admin, shop, engineering, et cetera, or just on-site employees?
I think that for that certification, I think it needs to be any employee who may have done work for the project. It doesn't necessarily need to be on site. Now that's really hard, right? Because does that include the accounting people that paid the invoice, that supported the whatever, or ordered the product? Time will tell on that one, but usually it's going to be people who've touched the project, almost like if you were looking at on federal or state projects, you know, how are they looking at it? Not as limited as a certified payroll, certainly, but you know, who really had some impact related to the project.
I think we've hit on this next question, but I think maybe just a little further clarification. Is the GC responsible for only first tier sub and supplier, or also down in all tiers?
Well, I believe that the statute is clear that it is only the first tier because it incorporates the definition of subcontractor from the mechanics lien statute, which defines a subcontractor as somebody who has not contracted directly with the owner, but has contracted with the general contractor. There is a little bit of ambiguity because the mechanics lien statute actually goes down to the third tier. A supplier to a subcontractor would have a mechanics lien, but under the statute would not actually be considered a subcontractor. So I think it's only the first tier.
Yeah, I'll tell you, Tom and I emailed about that last night and talked about that first thing this morning. This is not a perfect statute. So I would expect plaintiff's attorneys to test what Tom just said.
Perfect. Next comment and question is, so the bottom line is, if you've paid the sub and had no knowledge of any claim despite all due diligence, and then the sub does not pay their employees and the sub is not able to pay them, you ultimately have to double pay and compensate their employees?
No, that is the big question. It asks the question of when does the knowledge requirement apply? I believe that the ultimate resolution of that question will be if you had no reason to know at the time that you made your payment to the sub, then the general contractor is not going to be responsible. But as we've said, it is not crystal clear under the statute.
Can we add language to our contractor lien waivers for certification of employees are paid?
If your contract allows, I mean, if it's an existing contract, you would need to get the approval of your subcontractor to whatever modification you make, including the modifications to the lien waivers, probably. But you know, because this is a new statute that imposes a potential new liability, I think most subcontractors are going to understand that now this is something that is not being necessitated by you, the general contractor, but it's been necessitated by the General Assembly, and will agree to the modification, if not to the contract itself, then to the lien waiver language, which would be as good if you are, it's not as good for indemnification, but it is as good for getting the certification that their employees are paid. And with most lien waiver forms, that would be really a pretty minor modification.
I think we've got, I'm sorry, go ahead.
I was gonna say that those changes may come down from owners too. I mean, we've been talking with owners about the statute, and owners are nervous about labor disputes on their projects. And you know, some of our partners in Baltimore, you know, focused on project labor agreements and collective bargaining. I mean, the labor unions, you know, have a pretty specific agenda, it seems, and they've been successful in Virginia. So, you know, we're gonna have future webinars on some of these other you know, impacts, you know, associated with labor, and, you know, owners may be pushing some of these changes and certifications all the way in their flow down contracts in order to make sure that people that do work on the job are paid.
It looks like we have just a couple more questions over in the chat bar as well. One of which is, does the subcontractor or supplier need a direct contract with the GC? Or does it include sub and suppliers that do or do not have contracts?
Yeah, we've addressed that, and I believe the statute is clear that it's talking about subcontractors that have a direct contract with the general contractor, because it incorporates the definition from the mechanics lien statute.
That seems to be the hot question today.
As well it should be.
Yeah.
The last question we have is, can you make sub-employees on the project sign a statement that they have been paid properly each week?
So some contractors will go to that. Yes, you can. Again, that begins to bleed over into the concern that I also had earlier, which is you begin to start to have a lot more information that makes you look like an employer. But I think that's a good tactic to try to make sure that you did your due diligence to try to make sure that people were paid. Now, whether they're truthful when they sign it or not, who knows?
Well, that's all the questions that we have that have been posted today. But I will reiterate to all of our attendees that we are sending out the recording of this webinar, the PowerPoint, and you'll have contact information for all of our panelists. So we hope that the conversation continues, beyond this webinar as you all, have questions or comments that you'd like to share. Panelists, do you all have anything else before we sign off for today?
Nope, it's been a pleasure.
You've
Thank
been
you.
excellent. Thank you so much. We appreciate it. And we hope to see everybody again next Thursday for the third part in this series. Thank you all.
Thanks.
Take care.